Welcome back to Criminal Procedure CRJU 201A. Today we will be discussing the sources of criminal procedure. Today we will focus on the foundational concepts of criminal procedure and the role of the Constitution, and particularly the 14th Amendment. We will begin by examining the main sources of criminal procedure, including statutes, judicial decisions, and constitutional provisions. You will learn how these sources guide the criminal justice system and protect individual rights. A key component of this discussion is the 14th Amendment. We will explore the Due Process Clause and its role in ensuring fundamental fairness, as well as how it has been used to apply or incorporate many rights from the Bill of Rights to the states. We will also consider the Equal Protection Clause and its significance in ensuring that laws are applied fairly to all individuals. We will discuss the impact of Supreme Court decisions in shaping criminal procedure and consider the two main models of criminal justice: the crime control model, which emphasizes efficiency, and the due process model, which emphasizes fairness. Finally, we will touch on the relationship between criminal procedure and public perceptions of fairness in the justice system. By the end of today's lecture, you will have a clear understanding of these key concepts, which will provide the foundation for the rest of our study of criminal procedure. Criminal procedure provides the outline, or the map, for investigating, prosecuting, and punishing crime. The rules of criminal procedure are meant to serve as a guide to police, defense attorneys, prosecutors, and judges. Criminal procedure covers a number of rights. However, as we will discuss today, many of these rights did not exist for a number of years until the Supreme Court took on its role as the interpreting body for the Constitution. In fact, it wasn't until the movement for nationalization or constitutionalization, as some call it, that many of these rights became what most people view as implicit. The framers of the Constitution had the tyranny of Great Britain fresh in their minds when they began drafting the United States Constitution. As you can likely deduce, this made the framers reluctant to give the federal government any true overarching power over the states. A constitutional political system, or a political system in which the powers of the various branches of government are defined by a constitution, seemed like the most reasonable solution to the founders. While the first iteration of the Constitution did not do much for individual rights, the Bill of Rights quickly set out certain rights held by individuals, including the right to a jury trial, the right to due process, and the right to freedom of speech. However, this only truly applied in federal scenarios and did not apply with equal fervor to the states. It wasn't until the 14th Amendment was ratified that these individual rights were incorporated and made applicable to the states. The goal is to make these procedural protections uniform across the United States. The system needed to be more consistent to defendants and to hopefully prevent a defendant charged in Indiana and a defendant charged in Florida from facing disparaging differences in their treatment for a similar crime. The primary sources of criminal procedure are the United States Constitution, the United States Supreme Court, state constitutions and court decisions, federal and state statutes, rules of criminal procedure, and the Model Code of Pretrial Procedure. The original Constitution, adopted in 1788, only set out four provisions to address criminal procedure. Article 1, Section 9 addresses habeas corpus and ex post facto laws. Article 3, Section 2 addresses jury trials, and Article 3, Section 4 addresses treason. Habeas corpus guarantees individuals the rights to go before a court and require the government to explain why they're incarcerated. Further, Article 1, Section 9 limits the ability of Congress to suspend the privilege of the writ of habeas corpus. Article 1, Section 9 also prohibits Congress from adopting bills of attainder or enforcing legislative acts without a trial, and ex post facto laws which criminalize an act that was legal when committed. Article 3, Section 2 provides that all crimes shall be tried before a jury and that such trial shall be held in the state where the crime has been committed. However, this right can be waived by a defendant if they would prefer to go in front of a judge rather than a jury of their peers. Treason is a levying of war against the United States. A conviction requires the testimony of two witnesses to the same overt act or a confession by the accused in open court. The Bill of Rights, ratified in 1791, further establishes protections relevant to criminal procedure, including the Fourth Amendment, which protects against unreasonable searches and seizures and requirements for warrants, the Fifth Amendment, which provides grand jury indictments, double jeopardy, self-incrimination, and due process rights, the Sixth Amendment, with rights to a speedy and public trial, impartial jury, notice of charges, confrontation of witnesses, compulsory process for obtaining witnesses, and assistance of counsel, and the Eighth Amendment, with prohibitions on excessive bail or fines and cruel and unusual punishment. As previously noted, the Fourth Amendment protects against unreasonable searches and seizures and sets forth the requirements for the issuance of valid warrants. The Fourth Amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." The Fifth Amendment provides for indictments by grand juries, prohibition against double jeopardy, rights against self-incrimination, and the due process of law. The Fifth Amendment reads, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." The Sixth Amendment gives you the right to a speedy and public trial, an impartial jury of your peers, an informed charge, a confrontation of your witnesses against you, the right for you to obtain witnesses to support your case, and the assistance of a lawyer. The Sixth Amendment reads, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." The Eighth Amendment provides for protection against excessive bail, excessive fines, and cruel and unusual punishments. The Eighth Amendment reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." The United States Supreme Court serves as the ultimate interpreter of the Constitution. Under Article 6, the Constitution is the supreme law of the land, and all federal and state laws must conform to it. The United States Constitution is the supreme law of the land, and federal and state laws must conform to the constitutional standard. Alexander Hamilton in the Federalist Papers observed that the Constitution is the standard for the laws, and that where there is a conflict, the laws ought to give place to the Constitution. The constitutional requirements, however, are not always clear from the text of the document. The Sixth Amendment's provision for assistance in all criminal prosecutions, for instance, does not tell us whether the federal government and the states must appoint lawyers to represent the indigent and poor during police lineups, and does not tell us whether a lawyer must be provided free of charge to defendants undertaking an appeal following a conviction. In 1803, in Marbury v. Madison, the United States Supreme Court claimed the authority of judicial review, which is the right to define the meaning of the Constitution and to throw out federal, state, and local laws as unconstitutional that do not conform to the Constitution. Marbury is a complicated case to disentangle, and at this point you merely should appreciate the fact that the lasting significance of this famous case is Justice John Marshall's proclamation that an act that is repugnant to the Constitution is void, and that It is emphatically the province and duty of the judicial department to say what the law is. In two later cases, Martin v. Hunter's Lessee and Cohens v. Virginia, the Supreme Court explicitly exerted federal and state legislatures supplement constitutional protections by creating statutes that govern criminal procedure, often organized into codes of criminal procedure. States vary widely. Some provide detailed step-by-step rules, while others address only select issues such as media access, courtroom conduct, DNA testing, or extradition. These statutes help define defendants' rights, and their interpretation is handled by state courts for state laws and federal courts for federal laws. However, the U.S. Supreme Court may strike down any statute, state or federal, that violates constitutional rights. Overall, statutes play a critical role in shaping criminal procedure and work alongside the federal rules of criminal procedure. The federal rules of criminal procedure outline every major step in the federal criminal process, from filing a complaint through sentencing, including grand jury procedures, pretrial motions, jury instructions, verdicts, and post-trial actions. These rules are developed by the Judicial Conference of the United States, reviewed by the Chief Justice, and sent to Congress, where they take effect unless altered or rejected. The Supreme Court has ruled that these rules carry the force of law, meaning federal courts must follow them strictly, including deadlines for motions and restrictions on recording or broadcasting trials. Most states also have comprehensive procedural rules that mirror the federal system, and in about one-third of states, court-created rules take precedence over legislative statutes. The American Law Institute, or ALI, formed in 1923 by leading legal scholars and judges, created model statutes to help unify the widely varying criminal laws and procedures among states. Its model code of pre-arraignment procedure has influenced courts, including the Supreme Court, on issues like the proper length of investigatory stops and best practices such as recording police interrogations. Judges also frequently consult administrative procedures and professional guidelines, such as the DOJ's Justice Manual, State Bar Ethical Rules, and internal police regulations, when evaluating prosecutorial conduct, defense effectiveness, or police reasonableness. These standards can guide disciplinary actions or even impact the validity of a criminal conviction. The next section reviews how the Bill of Rights became applied to the states through the 14th Amendment's Due Process Clause. The nationalization or constitutionalization of criminal procedure occurred in the late 20th century, when the Supreme Court used the 14th Amendment's Due Process Clause to apply most of the Bill of Rights to the states, creating a single nationwide standard. As a result, a defendant's fundamental rights are largely the same whether prosecuted in state or federal court. Supporters argue that nationalization promotes fairness and consistency across jurisdictions, while critics contend that states should retain flexibility to develop procedures suited to their unique policing needs. Some worry that federal standards may hinder local law enforcement or overlook the realities of everyday policing. Ongoing Supreme Court debates will likely revisit how much uniformity the Constitution requires and how much autonomy states should retain. The 14th Amendment, adopted in 1868 after the Civil War, was intended to guarantee citizenship and protect the rights of formerly enslaved people by preventing states from denying due process, equal protection, or fundamental liberties. This represented a major shift from the Supreme Court's earlier ruling in Barron v. Baltimore in 1833, which held that the Bill of Rights restricted only the federal government, leaving states largely free to infringe upon individual rights. Although some members of Congress believed the amendment's Privileges or Immunities Clause would extend the Bill of Rights to the states, the Supreme Court rejected this interpretation in the Slaughterhouse cases of 1873. As a result, individuals seeking protection from state abuses turned to the amendment's Due Process Clause. By the mid-20th century, growing concerns about fairness in state courts fueled renewed efforts to apply federal constitutional rights at the state level. Lawyers increasingly argued that the Due Process Clause incorporated specific protections from the Bill of Rights. The Supreme Court responded with three approaches: fundamental fairness, evaluating rights on a case-by-case basis; a total incorporation, extending the entire Bill of Rights to the states; and selective incorporation, applying specific rights deemed essential to liberty to the states, including plus versions that added rights beyond the Bill of Rights. Over time, selective incorporation became the dominant method, leading to a more uniform standard of criminal procedure nationwide. The 14th Amendment reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." In Dred Scott v. Sanford, 60 U.S. 393, 1857, the United States Supreme Court stated that enslaved persons were not citizens of the United States and therefore could not expect any protection from the federal government or the courts. The opinion also stated that Congress had no authority to ban slavery from a federal territory. In 1846, an enslaved African American man named Dred Scott and his wife Harriet sued for their freedom in St. Louis Circuit Court. They claimed that they were free due to their residence in a free territory where slavery was prohibited. The odds were in their favor. They had lived with their enslaver, an army surgeon, at Fort Snelling, then in the free territory of Wisconsin. The Scots' freedom could be established on the grounds that they had been held in bondage for extended periods in a free territory and were then returned to a slave state. Courts had ruled this way in the past. However, what appeared to be a straightforward lawsuit between two private parties became an 11-year legal struggle that culminated in one of the most notorious decisions ever issued by the United States Supreme Court. Scott lost his case, which worked its way through the Missouri state courts. He then filed a new federal suit, which ultimately reached the Supreme Court. On its way to the Supreme Court, the Dred Scott case grew in scope and significance as slavery became the single most explosive issue in American politics. By the time the case reached the High Court, it had come to have enormous political implications for the entire nation. On March 6, 1857, Chief Justice Roger B. Taney read the majority opinion of the court, which stated that enslaved persons were not citizens of the United States and therefore could not expect any protection from the federal government or the courts. The opinion also stated that Congress had no authority to ban slavery from a federal territory. This decision moved the nation a step closer to the Civil War. The decision of Scott v. Sanford, considered by many legal scholars to be the worst ever rendered by the Supreme Court, was overturned by the 13th and 14th Amendments to the Constitution, which abolished slavery and declared all persons born in the United States to be citizens of the United States. In Slaughterhouse Cases 83 U.S. 36, 1873, the Supreme Court's decision was the first major decision interpreting the 14th Amendment. The plaintiffs, an association of white butchers in New Orleans, sued the defendant after Louisiana gave the defendant a monopoly over the slaughtering business in New Orleans. They argued that forcing the butchers to give up their businesses and operate in the defendant's slaughterhouse was involuntary servitude under the 13th Amendment, and that it violated their privileges or immunities as United States citizens under the 14th Amendment, including their right to earn a living in an ordinary calling of their choosing. They also argued that it violated their rights to due process and equal protection. The Supreme Court rejected the butchers' challenge and upheld Louisiana law. The courts held that the 13th Amendment did not apply because it was addressed only to slavery, and that the 14th Amendment's privileges or immunities clause applied only to federal citizenship rights and not to state citizenship rights. This holding dramatically narrowed the application of the 14th Amendment, especially the privileges or immunities clause. It also limited the Equal Protection Clause to cases of race-based discrimination only. The Due Process Clause of the 14th Amendment sparked significant debate over whether it was meant to incorporate the protections of the Bill of Rights and apply them to the states. Supporters of total incorporation theory argue that the framers of both the Constitution and the 14th Amendment viewed these rights as fundamental and intended for them to protect all citizens, including the newly recognized African American citizens after the Civil War. Advocates of total incorporation plus go even further, asserting that additional rights beyond the Bill of Rights should also be included. In contrast, proponents of the fundamental fairness approach argue that the Due Process Clause does not incorporate the Bill of Rights, but instead requires only that states conduct criminal trials in ways that meet basic standards of fairness. This view allows states greater flexibility and emphasizes the amendment's broad language, which does not explicitly mention the Bill of Rights. Critics respond that if the framers meant only fundamental fairness, they would have used the phrase rather than repeating the same due process wording found in the Fifth Amendment. A third approach, selective incorporation, holds that only certain provisions of the Bill of Rights, those considered essential to liberty, should apply to the states, leaving the rest of criminal procedure to state control. Some judges even support selective incorporation plus, adding rights not originally included in the Bill of Rights. These debates set the stage for the Supreme Court's gradual case-by-case incorporation of many constitutional protections into the 14th Amendment. The fundamental fairness approach emerged in a series of Supreme Court cases between 1884 and 1908, during a period when the court repeatedly refused to apply the Bill of Rights directly to the states. In Hurtado v. California, 110 U.S. 516, 1884, the court held that states did not need to use grand jury indictments, ruling that due process only required procedures consistent with basic principles of liberty and justice. This reasoning was reaffirmed in Twining v. New Jersey, 211 U.S. 78, 1908, where the court rejected a challenge involving the right against self-incrimination, but acknowledged that some rights might eventually be considered fundamental under the 14th Amendment. During the early 20th century, dramatic social and political change pushed the court to take a closer look at abusive state practices. In Moore v. Dempsey, 261 U.S. 86, 1923, the court overturned murder convictions obtained in mob-dominated trials, declaring that sham proceedings violated due process. This movement continued in Powell v. Alabama, 287 U.S. 45, 1932, where the court held that defendants facing the death penalty must be given meaningful access to counsel, especially when they are young, poor, or vulnerable. It reached a breaking point in Brown v. Mississippi, 297 U.S. 278, 1936, when the court condemned convictions based on confessions extracted through torture as a clear denial of due process. Together, these cases establish that the 14th Amendment prohibits criminal procedures that violate fundamental principles of justice, even if the specific right is not listed in the Bill of Rights. Under this approach, rights are protected because they are essential to ordered liberty, and states remain free to design their procedures so long as they do not cross that constitutional line. Next, we will examine the case of Rochin v. California, 342 U.S. 165, 1952. On July 1, 1949, law enforcement officers operating on a tip that someone was selling narcotics made for the two-story dwelling where Rochin lived with his mother, wife, brothers, and sisters. Officers finding the front door open entered the residence, where they then forced open the door to Rochin's room, where he was sitting partly dressed on the side of the bed with his wife laying beside him. On a bedside table sat 2 capsules, which Rochin proceeded to grab from the table and ingest. A struggle ensued in which the officers attempted to extract the capsules from Rochin's mouth, but were already swallowed. Officers handcuffed Rochin and took him to the hospital, where his stomach was pumped against his will and he vomited up the 2 capsules that were later found to contain morphine. Rochin was brought to trial and found guilty of possession of morphine and sentenced to 60 days in jail. Rochin claimed that his conviction should have been reversed because police officers entered his home without a warrant, tackled him to the ground, and then made a doctor pump his stomach against his will. This procedure produced the evidence of illegal drugs used to convict the defendant. Reversing defendant's conviction, the Supreme Court agreed that defendant's due process rights had been violated. The court found no distinction between a verbal confession extracted by physical abuse and a confession wrested from the defendant's body by physical abuse. Moreover, the court found that the police officer's conduct, by illegally violating defendant's privacy, struggling to open his mouth, and forcibly extracting his stomach's contents, shocked the conscience. The court ruled that the coerced evidence was inadmissible under the Due Process Clause of the 14th Amendment. Consider why Justice Felix Frankfurter concluded that the police violated Rochin's due process rights. Are you persuaded by his argument that the determination of the content of due process is an objective rather than a subjective process? What other police practices would shock the conscience that you can think of? Justice Frankfurter compares the police conduct in Rochin to the involuntary confessions in Brown v. Mississippi. He writes that the Supreme Court cannot credibly hold that in order to convict a man, the police cannot extract by force what is in his mind, but can extract what is in his stomach. Do you agree with the judge's comparison? The fundamental fairness doctrine dominated Supreme Court decision-making until the 1960s, but Justice Hugo Black strongly criticized it for lacking clear standards. In his dissent in Adamson v. California, 1947, he argued that the 14th Amendment was intended to totally incorporate the Bill of Rights, making all federal rights fully applicable to the states. Justice Black maintained that the founders viewed the Bill of Rights as essential to liberty, and the amendment's drafters would have explicitly used vague language, rights essential to liberty and justice, if that had been their intent. He also doubted that judges were competent to decide which rights were fundamental, warning that this approach allowed the court to improve on the Bill of Rights in ways that undermined the written Constitution. Although Black never persuaded a majority, some justices, such as Murphy, Rutledge, and Douglas, went even further by supporting total incorporation plus, which would apply the Bill of Rights to the states and recognize additional rights, such as environmental or health protections. Under total incorporation, the logic is simple. Due process refers to the Bill of Rights. The Bill of Rights identifies the protected liberties, and those liberties automatically apply to the states. Critics, however, questioned why the 14th Amendment does not explicitly state an intent to incorporate the Bill of Rights. Even so, the total incorporation argument played a major role in shaping modern criminal procedure by helping justify the extension of most federal constitutional protections to defendants in state courts. By 1962, the Supreme Court had a majority of justices favoring incorporation, but instead of total incorporation, the court adopted a selective incorporation approach, first articulated by Justice William Brennan. In Malloy v. Hogan, 1964, Brennan incorporated the Fifth Amendment right against self-incrimination into the 14th Amendment, holding that the same standards must apply in both state and federal courts. Selective incorporation applies those provisions of the Bill of Rights that are fundamental principles of liberty and justice to the states, while leaving states free to design procedures in areas that are not covered. This approach provides coextensive coverage, meaning incorporated rights are applied equally at the federal and state levels. The court has selectively incorporated most criminal procedure protections, including the right to counsel, a speedy trial, an impartial jury, and protection against unreasonable searches and seizures. A few provisions, such as the Third Amendment's prohibition on quartering soldiers and the grand jury requirement for capital crimes, remain unincorporated, allowing states discretion to adopt these protections. In Duncan v. Louisiana, 1968, the court incorporated the Sixth Amendment right to a jury trial, emphasizing that juries are fundamental to the American scheme of justice and serve as a crucial check on governmental power. While some justices, like Hugo Black, continued to advocate total incorporation, and others defended fundamental fairness, selective incorporation became the guiding doctrine for applying the Bill of Rights to the state. By way of example, the First Amendment was incorporated into the 14th by Fisk v. Kansas, 274 U.S. 380, 1927 for the freedom of speech. The Second Amendment was incorporated by McDonald v. Chicago, 561 U.S. 742, 2010, with the right to bear arms. The Fourth Amendment was incorporated in two separate cases, Wolf v. Colorado, 338 U.S. 25, 1949 for unreasonable searches and seizures, and Mapp v. Ohio, 367 U.S. 643, 1961 for the exclusionary rule. The Fifth Amendment was adopted in Malloy v. Hogan, as we discussed, against compelled self-incrimination, and Benton v. Maryland in 395 U.S. 784, 1969 against double jeopardy. The Sixth Amendment was incorporated in a series of cases. Gideon v. Wainwright in 372 U.S. 335, 1963, the right to counsel. Klopfer v. North Carolina, 386 U.S. 213, 1967, the right to a speedy trial. In re Oliver, 333 U.S. 257, 1948, a public trial. Pointer v. Texas in 380 U.S. 400, 1965, right to confront witnesses. Duncan v. Louisiana, 391 U.S. 145, 1968, for an impartial jury. Washington v. Texas, 388 U.S. 14, 1967, for the right to compulsory process for obtaining favorable witnesses at trial. And Ramos v. Louisiana, 590 U.S. 83, 2020. Unanimous jury verdicts in criminal cases. The Eighth Amendment was incorporated in two separate cases. Robinson v. California, 370 U.S. 660, 1962, for cruel and unusual punishment, and Timms v. Indiana, 586 U.S. 146, 2019, prohibition of excessive fines. Originally, the United States Constitution did not guarantee equal protection of the laws, reflecting the reality of slavery and discrimination against women. The 13th Amendment in 1865 abolished slavery, and the 14th Amendment in 1868 added the Equal Protection Clause, prohibiting states from denying individuals equal treatment under the law. The Supreme Court later recognized that the Fifth Amendment's Due Process Clause imposes a similar obligation on the federal government, as seen in Bowling v. Sharp, 1954, which struck down racial segregation in Washington, D.C. schools, noting that discrimination may be so unjustifiable that it violates due process. Equal protection is essential for maintaining public confidence in the fairness of the legal system. Yet, police, prosecutors, and judges routinely exercise discretion in arrests, charges, bail, and sentencing. Courts generally presume prosecutors act fairly, but the Equal Protection Clause prohibits decisions based on arbitrary classifications such as race, religion, or ethnicity. This was seen in Euler v. Boyles in 1962. Even laws that are neutral on their face may violate equal protection if they're applied discriminatorily, as seen in Yickwo v. Hopkins in 1886, where a San Francisco laundry ordinance was enforced almost exclusively against Chinese owners, demonstrating that biased enforcement alone can deny equal justice. To succeed in a selective prosecution claim, a defendant must show both discriminatory impact and discriminatory intent. Successful cases often involve prosecutions targeting specific groups for reasons unrelated to law enforcement, such as census resistance in United States v. Steele in 1972 or whistleblowing in People v. Walker 1964. Next, we will consider the case of United States v. Armstrong from 1996. In 1992, respondents, all African Americans, were indicted for conspiracy to distribute crack cocaine and related firearms offenses in California. The respondents claimed that they were selectively prosecuted because of their race and sought discovery to show the government ignored similarly situated non-black offenders. Their evidence included a paralegal's affidavit listing 24 prior Section 841 and 846 cases, all involving black defendants, and a study of federal crack prosecutions. The district court granted discovery, but the government argued that prosecution decisions were based on legitimate criteria, such as large quantity of crack, multiple defendants, firearms violations, and strong evidence. The Supreme Court considered what a defendant must show to obtain discovery on a claim that the prosecutor singled him out for a prosecution based on race. The court ultimately held that the respondents failed to meet this threshold as they did not demonstrate that similarly situated individuals of other races were not prosecuted. The Supreme Court emphasized that the broad discretion of federal prosecutors under Article II of the Constitution and the presumption of regularity in their decisions. To overcome this presumption in a selective prosecution claim, a defendant must show both discriminatory effect and discriminatory intent. Discriminatory effect requires evidence that similarly situated individuals of other races were not prosecuted, while discriminatory intent requires purposeful targeting. The court stressed that discovery imposes significant burdens on prosecutors and may reveal enforcement strategies, so only some evidence supporting both elements justifies discovery. Respondents' affidavits and study did not meet this standard, as they failed to identify non-black individuals who could have been prosecuted but were not. Ultimately, the Supreme Court reversed the lower court, ruling that the respondents had not provided sufficient evidence of selective prosecution to justify the discovery. However, Justice Stevens dissented. He argued that the district court properly exercised its discretion in ordering the discovery. He emphasized that federal crack cocaine penalties were disproportionately severe, especially under the 100-to-1 crack powder sentencing disparity, and that the evidence showed a striking racial pattern. Most federal crack prosecutions involved black defendants, while white defendants were largely prosecuted in state courts. Stevens argued that affidavits from attorneys and a drug counselor provided relevant first-hand evidence of discriminatory prosecution patterns, sufficient to warrant discovery to ensure fairness. The key takeaways were that selective prosecution claims required showing discriminatory effect and discriminatory intent. Courts generally defer to prosecutorial discretion, but may intervene if credible evidence of racial or other improper targeting exists. Discovery in selective prosecution cases is limited and requires at least some evidence of unequal treatment in similarly situated individuals. Stevens' dissent highlights the real-world impact of sentencing disparities and enforcement patterns on racial fairness. In United States v. Bass, 536 U.S. 862, 2002, John Bass was charged with killing 2 individuals and faced the federal death penalty. He requested discovery regarding the federal government's death penalty charging practices, presenting data from the federal death penalty system, a statistical survey, 1988 to 2000. The data showed that African Americans were charged with death-eligible offenses more than twice as often as European Americans. Among death-eligible defendants in the Eastern District of Michigan, 14 of 17 were African American and 3 were Hispanic. The government entered into plea bargains with European Americans almost twice as often as with African Americans in death-eligible cases. DOJ officials, including Attorney General Reno and Deputy Attorney General Holder, expressed concern over racial disparities in death penalty charges. In the lower court, the Sixth Circuit held that the statistical disparities constituted some evidence of discriminatory effect and intent, justifying discovery. The plea bargaining data indicated a pool of similarly situated defendants treated differently by race, and the lack of similar disparities in non-death eligible offenses suggested race might influence the death penalty charging process. In the Supreme Court's decision, it held that Bass failed to make a credible showing that similarly situated individuals of a different race were treated differently, and therefore reversed. Nationwide statistics, even on plea bargains, were insufficient because they did not focus on defendants truly similarly situated to Bass in the relevant jurisdiction and circumstances. The court emphasized the Armstrong standard. To obtain discovery for a selective prosecution claim, a defendant must identify comparable defendants of a different race who were not prosecuted or treated differently. Armstrong establishes a high threshold for selective prosecution discovery. Both discriminatory effect and intent must be shown, and similarly situated comparators are required. Nationwide statistics alone are insufficient. Evidence must be specific to defendants comparable in the same circumstances. The case highlights tension between protecting prosecutorial discretion and ensuring equal protection under the law in capital cases. SCOTUS, for a number of years, largely ignored the issue of retroactivity of judicial decisions or the impact of a decision announcing a new rule on other cases. New rule is defined as a procedural requirement that the court heretofore had not required. An example would be the Supreme Court's holding in Gideon v. Wainwright that the Sixth Amendment right to counsel is applicable to the states through the Due Process Clause of the 14th Amendment, and that states are required to provide legal representation to indigents charged with a felony. Clarence E. Gideon had been denied counsel at his trial, and the Supreme Court accordingly reversed his conviction. The question is whether individuals who were convicted prior to the decision in Gideon would be provided with a new trial. As the Supreme Court became actively involved in criminal procedure decisions, judges became concerned that a decision announcing a new rule on interrogations, lineups, searches and seizures, or other areas would permit every person in federal or state custody, in prison or on probation or parole, whose conviction was obtained under the old rule, to file a writ of habeas corpus challenging their conviction. Many of these individuals had been convicted years ago, and a retrial was not always practical. Witnesses would likely prove difficult to locate, memories may have faded, and records likely would have disappeared or been destroyed. The criminal justice system also could not absorb an avalanche of new trials and appeals. This is a philosophical as well as a practical question. A Supreme Court ruling might be viewed as a statement of the law as it always existed, in which case individuals in custody should be authorized to rely on the new rule in challenging their convictions. The problem is that this would open wide the courthouse door to a cascade of appeals. The Supreme Court, in a series of cases, wisely decided that courts should follow the rule that existed at the time of the final decision, and that the new rule would not be available on habeas corpus review. The Supreme Court recognized at the same time that it would be unfair to benefit the individual before the court whose case had resulted in the new ruling, while denying the same benefit to individuals whose cases raised the same issue and were currently at trial or on appeal. In brief, the Supreme Court applies the new rule to cases that are pending and denies the new rule to cases that are final. The rule of retroactivity is summarized as follows. The new rule applies to cases that have not yet been brought to trial and to trials that are currently being conducted. The new rule applies to cases that are on direct appeal or about to be appealed. The new rule is not available to individuals in cases in which the judgments have become final before the new judgment is issued. These are the individuals who have exhausted their appeals as a matter of right and now must rely on habeas corpus review of the constitutionality of their conviction. The Supreme Court reserves the right to make a judgment fully retroactive in a small handful of what are considered watershed judgments. Another impact of a Supreme Court decision is that a host of questions inevitably arise in lower courts that require the Supreme Court to explain its opinion. In 1966, in Miranda v. Arizona, the Supreme Court held that prior to interrogating a suspect who is in custody, the police are required to provide the suspect with a three-part Miranda warning. Over the past 3 decades, the Supreme Court has issued decisions in more than 35 cases interpreting the requirements of Miranda that address questions such as the definition of custody, how the rights are to be read, and the standard for waiving and invoking the Miranda rights. A Supreme Court judgment is intended to impact the enforcement of the criminal law. The fact is that the court cannot wave a magic wand after it issues a decision and immediately change the behavior of thousands of police officers, prosecutors, and judges. As a result, decisions often are not fully implemented. Even after a number of years, a second aspect of the impact of a Supreme Court decision is that judgments may have unanticipated consequences. The Supreme Court believed that informing suspects of their rights would encourage individuals to assert their Fifth Amendment right against self-incrimination. Professor Gerald N. Rosenberg, in his study of the impact of Supreme Court decisions, found that the Miranda rights have had virtually no impact on the frequency of confessions. Professor Rosenberg recounts several factors that have limited the impact of Miranda and the decisions explaining the Miranda judgment. A number of police officers continue to resist Miranda and give the warnings in a way that discourages individuals from asserting their rights. The police are not always able to keep track of the new Supreme Court decisions that are issued regarding interrogations. Some suspects feel a social or moral obligation to speak or may believe that the prosecutor may reduce their charges if they're cooperative. Defendants do not always understand the Miranda rights and, for instance, do not comprehend why they should remain silent. Suspects may have a great deal of incorrect information. They may believe that only written confessions are admissible in evidence at the trial, and that they are free to talk to the police without their statement being used against them at a trial. We have now completed our discussion of the sources of criminal procedure, the incorporation debate, and equal protection. A criminal justice system should provide timely and accurate verdicts while ensuring fair treatment for all individuals, free from discrimination. This requires the balancing of several goals: efficiency, accuracy, fairness, and equality. Efficiency means that cases should progress quickly from arrest to conviction or acquittal with timely appeals. Accuracy means that the system should aim to convict the guilty and avoid punishing the innocent. Fairness means that suspects must be protected from abuse, corruption, and human error. And equality means that everyone should receive equal treatment regardless of their race, religion, ethnicity, or income. These goals often conflict. Speed may compromise detailed procedures, while extensive protections can slow the process. Herbert Packer illustrates this tension through 2 theoretical models: the crime control model and the due process model. The crime control model emphasizes rapid suppression of crime, prioritizing efficiency over procedural safeguards. Police and prosecutors act quickly to investigate, charge, and convict with minimal interference from trials or appeals. Its key features include crime prevention and punishment being paramount, speed and efficiency are prioritized over technical rules, police and prosecutors, rather than courts, are relied upon to distinguish the guilty from the innocent. And by contrast, the due process model focuses on protecting individual rights and ensuring accuracy, even at the cost of efficiency. Detailed procedures safeguard against errors, coercion, and corruption. Its characteristics include crime prevention is important, but must be balanced with individual rights. Police prosecutors must follow strict rules to ensure fair and reliable outcomes. Trials and appeals serve as checks against mistakes and misconduct, reflecting the principle that it is better for 9 guilty people to go free than 1 innocent person to be wrongfully convicted. The United States system does not fully adopt either model. The Supreme Court constantly seeks a balance between efficient crime control and the protection of individual rights, ensuring that the criminal justice system maintains public respect and confidence. While the primary goal of the criminal justice system is to detain, convict, and punish the guilty, it is equally important to consider how convictions and punishments are achieved. Psychologist Tom Tyler's research on procedural justice shows that public confidence in the system depends more on whether fair procedures are followed than on the case outcome itself. Tyler identifies 4 key factors that shape perceptions of fairness: whether or not individuals have a voice and can tell their side of the story, whether decisions are neutral and based on consistent rules rather than personal opinions or prejudice, and officials explain their reasoning to the public, respect, where people are treated politely and with dignity, and trust, where criminal justice professionals are perceived as honest and committed to doing their job well. Tyler's findings suggest that people of all races, religions, ethnicities, and income levels will view the criminal justice system as legitimate so long as the process is fair. Legitimacy arises from the combination of voice, neutrality, respect, and trust. Fair procedures also increase the likelihood of correct outcomes. In short, how we reach a resolution is often as important as the result itself. Let's look at criminal procedure in the news. The American public generally considers the handgun the quintessential self-defense weapon. Handguns are easily accessible in emergencies, require little physical strength to use, and are difficult for an attacker to wrest away. Over the past several decades, some cities and suburbs have placed restrictions on handgun possession, even for self-defense, citing risks such as impulsive violence or firearms falling into the wrong hands. Gun rights advocates have long argued that these limitations violate the Second Amendment, which states a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Courts historically emphasized the well-regulated militia clause, holding that the Second Amendment protected gun ownership only in connection with service in organized militias. In United States v. Miller in 1939, the Supreme Court upheld a federal law prohibiting the interstate shipment of sawed-off shotguns, reasoning that Second Amendment protections were limited to firearms with a reasonable relationship to the preservation or efficiency of a well-regulated militia. The decisions reflected the traditional view that the Second Amendment was intended to prevent the federal government from abolishing state militias, not to protect individual self-defense rights. Gun rights activists argued that the Second Amendment also protected an individual's right to possess firearms unconnected with militia service, asserting that firearms are essential for preserving individual liberty. In District of Columbia v. Heller in 2008, the Supreme Court reversed precedent and held that the Second Amendment protects the right of individuals to possess firearms for self-defense in the home. Dick Heller, a D.C. special police officer, challenged a D.C. ordinance that banned handguns and imposed strict storage requirements. Justice Scalia, writing for the majority, held that the law interfered with the core lawful purpose of self-defense in the home. The court emphasized that while the Second Amendment is not unlimited, restrictions such as prohibiting felons or the mentally disabled from possessing firearms, regulating sales, or forbidding guns in sensitive places remain constitutional. Heller applied only to federal jurisdictions. In McDonald v. Chicago in 2010, the court addressed whether the Second Amendment applied to state and local governments through the 14th Amendment's Due Process Clause. The court, in a 5-4 decision authored by Justice Alito, held that the right to keep and bear arms for self-defense in the home is fundamental and deeply rooted in United States history, making it applicable to the states. The decision noted the historical recognition of this right from the English Bill of Rights in 1689 and Blackstone's legal writings in 1765. Justice Stevens dissented, noting that states and localities have historically regulated firearms differently, with urban areas tending to be stricter than rural areas. In Caetano v. Massachusetts in 2016, the court held that the Second Amendment protects modern weapons such as tasers, not just those in existence when the amendment was drafted, and not limited to weapons of war. Post Heller and McDonald, courts have addressed various state and local firearm regulations. Laws prohibiting firearm possession by juveniles, felons, domestic abusers, individuals with mental health commitments, and in sensitive places such as schools or government buildings have all been upheld. Courts have also affirmed regulations on machine guns, assault weapons, large capacity magazines, safe storage requirements, and commercial sales restrictions. In Kachalski v. County of Westchester, 2012, the Second Circuit upheld New York's law requiring a proper cause to carry a firearm outside the home, recognizing the state's authority to regulate public firearm possession. In Moore v. Madigan in 2013, the Seventh Circuit struck down Illinois' flat ban on carrying loaded firearms outside the home, emphasizing that self-defense needs may exist beyond the home. In Wren v. District of Columbia in 2017, the D.C. Circuit held that the good reason requirement for concealed carry permits effectively prohibited most residents from exercising their Second Amendment rights. In Young v. State of Hawaii in 2021, the Ninth Circuit, sitting en banc, upheld restrictions on carrying firearms in public, reaffirming that the core of the Second Amendment protects self-defense in the home, not in public spaces. According to the Giffords Law Center, 5 states, including California, Florida, Illinois, New York, and South Carolina, and D.C., generally prohibit open carry of handguns. 31 states allow open carry without a permit, though sometimes firearms must be unloaded. 6 states and D.C. generally prohibit open carry of long guns, while federal law imposes no general restriction on public carry. Other issues include assault rifle bans in some states and the implementation of red flag laws permitting temporary removal of firearms from individuals deemed a risk. In 2021, the Fourth Circuit affirmed that federal minimum age requirements for firearm purchases protect the Second Amendment rights of 18 to 20-year-olds. Some states, including Texas, allow students and faculty to carry concealed weapons on college campuses. Having covered the sources and purposes of criminal procedure, I'll plan on seeing you in Chapter 3.